Good morning, everyone. I think we're started. Welcome to the Burr Morning Show. Thank you for joining us this morning. We appreciate everyone's time. My name is Logan Hinkle. My partner, Bob Ellerbrock, is joining us. We're both employee benefits lawyers attached to Burr's Birmingham office. Our primary areas of practice involve qualified retirement plans, medical plans, and executive comp. Today, we're going to give you basically an ERISA update. We're going to talk about what seem to be, what in our experience are the hot topics surrounding retirement plans and medical plans in the remainder of 2025. We're going to talk a little bit about Secure Act 2.0 and some of the decisions that you guys will face with respect to your plans and Secure Act 2.0. We're going to touch a little bit on fiduciary hot topics, things, challenges, litigation items that we see affecting plans. And hopefully, if we have a little bit of time, we're going to talk about PBMs. So with that, I'm going to kick it to Bob, and we're going to go ahead and get started. Oh, and one more note, we are going to have some time for some questions, but we'll take most of those toward the end. If so, Bob, all you.
All right. So we're going to start today with going over this Secure 2.0 amendments, talking about the deadlines that are ever changing, it seems. Many of you have probably already made some of the decisions. We have several clients that are still deciding on some of those issues. And those are the items that we included in this show. If there's topics to discuss, we're going to talk about some of the reasons why to select certain items and others to maybe avoid, depending on your demographics and the relationship that you have with the participants. Back in 2023, they extended the deadline. It was originally going to be 2025. They actually extended it again till 2026. And the way they worded it, they said at least 2026. Part of that is there are several items that I think they're still working on, in typical governmental fashion. They say things that may not be easy to implement operationally. And I say easy, some of them are actually impossible, the way the law is written. So that's what we're going to talk about. But as of right now, the amendments are due in 2026. CARES Act, which was pre that, some of those are coming out, especially if you're on a prototype or volume submitter. The providers are starting to send out those amendments, and I know they're sending out the tack on or just the base CARES Act amendment probably within the next month or two.
Yeah. And so just unfortunately, this is common. We see this all the time. The IRS, frankly, if everybody remembers when Secure Act 2.0 first came out, there was this scramble dealing with Roth catch-up contributions, right? It was basically immediately effective. That's been pushed back repeatedly. We're actually going to talk about that a little bit later, but we see these sort of delays constantly. And I agree with Bob. There'll probably be additional delays, at least with respect to Secure Act 2.0 and the required amendment time.
So we're going to start with going through some of the options that we see. I'll say the questions that we're asked most about regarding Secure 2.0. We're going to start with, and this is pretty straightforward, but if you have an automatic enrollment program, they raised the deferral rate, the maximum deferral rate to 15% up from 10%. And that actually was effective for this year if you chose to do so. Most of the clients that I have that have automatic enrollment have decided that they're going to go ahead and do it because there's really, it's giving them the option and letting them go forward with it.
Yeah, and I'm seeing the same thing. I personally am a big fan of automatic enrollment. Bob, you may have seen the same sort of studies I have. Most of what I have seen suggests that you don't really get a lot of pushback on automatic enrollment until you're up into the 13, 14% range. What we see is inertia is an incredibly powerful force in these plans. People just, they don't think about it, they don't change their elections, and if they are gradually bumped up over time, it tends to stick. And next thing you know, you've got people, even non-highly compensated folks, deferring a significant amount of money into the plan and therefore saving more for their own retirement, which, seems like a good thing.
Yeah, and this is kind of dating myself, but if you remember when automatic enrollment came out, everybody was HR and to be honest, myself included, did not want to go through the hassle of people opting out after they started taking the money.
Mhm.
And the studies have shown, people don't necessarily want to do anything.
Yep.
So once they're in and they don't really think about it. So it's working out really well. Hopefully for the next generation to have better savings in their retirement funds. So Logan, you want to talk on the next one? Because I think this is kind of I think it's a nice option for employers if they're in the boat where
Yeah,
they
I
need
think
testing.
I think it is, and it's a very good option, especially for employers who have had a lot of refunds in the past where they get highly compensated employees that are having to get money back every year. At a certain point, that gets frustrating, and you tend to get people who are very upset about it. And not only that, it's your highly compensated employees. So it's people who are, excuse me, in a position to kind of make your life miserable. But so this gives an option to enact a non-elective. Now, it's only the non-elective, it can't be the match, but a non-elective safe harbor uh, to essentially take care of that issue. Okay. So you can adopt it at least 30 days before the close of the plan year, and it's got to be a 4% contribution. Um, I'm sorry, it's got to be a 3% contribution, but 4% is before you can do that a little bit later. So it's an expensive option, but I think it is gives you a lot of flexibility to do that. And Bob, I don't know if you want to add anything to that or not, but it's, for the right plan, I think it's very valuable.
Yeah, no, agreed. I think it gives, depending on demographics, obviously, and if it's affordable, um, the fact that you don't have to project a year out, which has been the normal safe harbor plan, you have to give the notice before the plan year even starts. This is letting you make that decision, November 30th of the year if you're going to do a 3%, or if you're going to do a 4%, you can actually do it the following year. Make that decision, make that contribution, and avoid the refunds. So it does give a little more flexibility. Obviously, not every plan can do it, um, but it will work well for, especially the smaller groups, where it's not going to be all that costly. So I think it's a good option.
Yeah, again, I think you got to pick your spots with the right demographics, right group, but this is something I think is very valuable for the right plan.
So the next one we're going to talk about is student loan matching, which is actually kind of
Yeah,
it
you
was a- it was a- I was
talk
gonna
about
say
having to have the right plan to make this work.
yeah, it was a hot topic when they first started talking about it a couple years ago. There was a private letter ruling that said that they could do it, but the IRS never really said yay or nay as far as across the board. So as part of the Secure 2.0, they actually did come out and say, yeah, we can make qualified student loan payments, which is basically in lieu of match, and I shouldn't say in lieu of match, But instead of max going into the retirement account, into the 401k plan, they're actually going to make the payments on the student loan. So this gives, the younger, well, I shouldn't say younger, predominantly younger group where they can actually not only save for retirement, but they can also work towards getting extra money paid on those student loans. Honestly, I haven't had anybody bring it up since they've passed this. Logan, I don't know if you've had anything
Uh,
or.
the next one will be the first. I keep waiting for a medical practice or a law firm or some other professional services group to bring it up. That's the only place I can think of that um, it would probably be a good fit, but we just haven't seen. I have not seen very much of this, and I'm not aware of any of our clients that have implemented it.
Yeah, I think it's going to be interesting. Depending on who's advising the plan, right? Because the financial advisors don't have it. There's no benefit to them to push the issue. And that's typically what, from my own personal experience, it's whatever kind of the flavor of the week is, as far as what the trends will be. And then once you start seeing it, you'll see a bunch of them. I'm just curious to see how this will, if it ever takes off, and who's really going to be pushing for it.
Yeah, I'm kind of a believer that retirement plans are retirement plans and loan repayments are kind of different. So again, I think there are plans that this could be great for. I just don't know that it's going to have very many. And I did ask, I was in a quarterly meeting with one of the record keepers, and I asked one of the larger record keepers, and I asked them if they had implemented any of these provisions just yet. And I think across their platform, it was still in the single digits, and these are just thousands and thousands of plans. So, um, you know,
Yeah.
maybe, but
Theoretically, it's a great idea. I just don't see a driver for it at the moment. So
I agree.
withdrawals, this is what, to be honest, getting most of the questions from clients as far as which way do they want to go, which way should they go, reasons for and against. Secure 2.0, I want to say added 4 to 5 different withdrawals that will be won't incur the 10% penalty for early withdrawal, and they also have kind of like the COVID loans where you could actually pay them back.
Bob, do you know of any COVID distributions that were repaid?
I do.
Wow, that may be the only one.
Not a lot, but yeah, no. I had several clients working through the process to how it was supposed to be repaid and classified and categorized. So I do know of at least two.
Wow.
So we'll start with the birth or adoption. Um, it's up to $5,000 within a year following the birth or adoption of a child, and it's not subject to the 10% penalty. Um, Notably, it's kind of like a hardship. It's not eligible for a rollover, so there's no mandatory 20%, but they will have to pay it at the end of the year. And this is also one of those, like I said, that can be paid back over time. So I
I'm sorry, go
go
ahead,
ahead.
Bob.
No, I was going to say this is one of those provisions that I typically tell clients that it doesn't hurt you to have it in there. It does give them the option to pay it back now. So, it's a little better than them taking a hardship or some other withdrawal. There's at least a chance that they pay it back.
Yeah, I agree with that. And I think I've seen this one implemented a few times. To me, other than the next one, the disaster relief distributions, this is probably going to be the most popular and the most commonly adopted of the withdrawals. Kind of like you, I think it's valuable in some cases. I mean, especially with, um, adoptions, which are outrageously expensive. Not that births aren't either, but it's valuable. And like I say, I've had a few clients that have adopted these provisions, and they seem to be very well received.
Yep. The disaster relief distributions to me, I have not had a client that has not included this in the
Yeah,
document.
I think
Um,
I agree. I think it's almost a no-brainer.
yeah, and particularly being in the southeast, we seem to have at least one a year, so
Yeah.
within the footprint. Um,
It's significant as well. It's $22,000 per disaster. So this could be something that, if someone's house gets hit by a hurricane or something like that, this could be, extremely important to them and really help them recover from, an awful situation.
yeah, and so some of you may be asking, don't we already have these? Prior to this, they would actually have to name they would have to name the disaster, and then you'd have to do the amendment. It would be the disaster relief for whatever the hurricane or other event was. Basically, this is just putting anytime it's declared, it will automatically be included, and then you have 180 days from that date to take advantage of it. This one I think is kind of I'll start with saying I don't have anybody that has used this one because it it's $1,000. It's for emergency expenses. Most people are kind of taking, especially if they have loans, that they're just not adding it. Um, Logan, have you seen anything on these or?
No, and I'm not a fan of these. What you're gonna, the fear, and I think it's legitimate, is that these are gonna be used as cash advances. I mean, you're gonna see people cycling through this all the time, and it's
Yeah.
$1,000. It's not, for a true emergency. Unfortunately, $1,000 just isn't gonna go that far for most people. So, I have not seen a whole lot of these implemented. I think I've seen one, but that's about it. And I have not seen a whole lot of interest in them.
And again, dating myself, but I always refer to it's going to turn into like the Christmas savings club.
Mhm.
So that's what they're going to use it for. And I will again, once again, they do give you the ability to repay that, which I think is good if you're in that situation and you need $1,000 for whatever the case may be. But at this point, I have not seen anybody, and for those very reasons. This one is actually probably the most discussions I have with clients, and this is the victims of domestic abuse distributions. This allows a victim to self-certify and take money out if they're experiencing or have experienced domestic abuse. Again, I think theoretically, I get it from the high level. I think the problem and the discussions that I typically have are just the fact of how much do we want to get involved in personal lives and how much information is too much information, and also from the participant side, how much do they want to share? So I don't know
Mhm.
how much it would be used. I have not had a single client include this. Um, for for those reasons. From a practical side, don't know if they want to share and also how much they want to get involved. I don't know what you're saying.
I've had one client that I'm aware of include this. And it's one of those things that, it's certainly a worthy reason to have a distribution, and, there's good intentions here, but honestly, that particular client has had the exact issues you discussed. It kind of puts them in an awkward position, right? Even with the self-certification, because there are still questions that come to the HR department, and it's just It's something that I agree that good intentions, but maybe not where you really want to be. My advice to my clients and the discussions I've had has been, let's hold off on this and sort of see how it plays out. But most are not implementing this now and taking kind of a wait and see approach.
Yep.
Mhm.
So you want to touch base on this one?
Sure. So this is one that is one of the biggest kind of gotchas that we run into on a frequent basis. And these are the penalties associated with failing to file or filing a delinquent or incomplete Form 5500. That's the annual report. And invariably, and I understand where people are coming from this, it sort of seems like a minor thing, right? It's not, it's easy to be a little bit late. Somebody, the person who's normally responsible for it left the company, whatever, lots of valid reasons. And unfortunately, the penalties associated with this are just staggering. The IRS penalty, which we didn't used to worry about all that much, has now been increased up to $250 per day to a maximum of $150,000 per 5,500. That is obviously a lot. It pales in comparison to the Department of Labor penalties, which are, looked it up, currently $2,529 per day with no maximum. The good news is there is a program where you can file late 5500s and basically get rid of these with no issue. The nominal fee, it's $2,000 for a large plan and less than that for a small plan. So if you take nothing else from this presentation, just keep in mind that 5500s are a potentially significant source of liability, and do everything you can to either get them filed on time, or if they are late, hurry up and take the steps necessary to file through this correction program and abate the penalties that would otherwise apply.
Yeah. And unfortunately, where we see these, even with, like, people that are really doing a good job as far as keeping everything in order, the 5500s that I see missed are almost always dealing with the health and welfare side. And it's one of the ancillary plans as far as, vision, um, EAP, whatever it is, it requires a 5500 and they just didn't know, or that the TPA didn't end up filing it for them. And they do have it, do have the systems talking to each other. So you will, if you file a retirement, a 5500 for your 401k plan and retirement plan, you may see, based on those number of participants, a letter asking why you don't have a health and welfare 5500 file. And the 5500 audits that they are randomly doing, and I went through 3 of them last year, used to be a very simple, we want to see your 5500, we want to see last year's. Now all of a sudden you're sending a packet of documents that's probably up to my waist. I think they're a little overreaching, and I'm hoping that dies down a little bit now that the IRS is woefully understaffed. And, I'm sure Logan's having the same experience, but I think there was a tremendous knowledge dump during COVID with the IRS. So anytime you get somebody, it's somebody that's new without experience, and everything's taking a lot longer than it should. So,
Yeah, there have been some layoffs in the IRS at the IRS as well. So what was always a slow process has slowed down even more recently. It's really moving at a glacial pace. Bob, I'll tell you another situation where I see this come up a bunch with 401k plans is a failure to include an audit. if the 401k plan has to include an audit as well, sometimes for whatever reason, the audit's just not complete. And if you send it in that way, then that's essentially the same thing as not filing the 5500. So get that issue occasionally. If it does get to the point where the DOL is assessing penalties, there is a phase in that process where you can respond to the Department of Labor and offer some quote unquote good reason for the delay in filing or failure to file. And what I have seen, and I think this is pretty common, is at that point you can't get by with no penalties, but there will be a significant reduction in the penalties that you see that the DOL is attempting to impose. And, so better than nothing. You really don't want it to get to that point, but if it does get to the assessment phase, you can at least get some relief if you do respond.
Yeah, and important to that is they will send you the initial letter. It is important to respond to that initial 30-day letter. My experience has been if you ignore the first letter, by the time they send you the second or third, they're much less reasonable for to accept your good reason.
Okay.
So Logan alluded to the catch-up contributions going forward, and it has been confusing and has been pushed back several times. So Logan, since you started, I'll let you go ahead and talk.
Okay. Hold on just a second. All right. So what we've got, and this was originally supposed to be effective for 2024. Is that right,
Yeah,
Bob?
that is
Yeah,
correct.
24. So we pushed it back 2 years at this point. So what Secure Act 2.0 says is if you are catch-up eligible, which is 50 or turning 50 in the year in question, and you are a highly compensated individual, then your catch-up contributions have to be Roth, have to be made as Roth contributions. This was a little bit of an issue for plans that didn't offer Roth deferrals to begin with. So we had sort of a scramble there trying to put these in place. I think mostly that has kind of passed us by now, and everybody's kind of ready for that point. But there's still a lot of confusion in this area. As we noted in the second bullet point there, the threshold on wage, the threshold for highly compensated in this particular case is based on wages. There's a lot of people who make very good money who do not have wages, partners, members of LLCs, that sort of thing. And Bob, correct me if I'm wrong, but to my knowledge, that has not been addressed yet.
That has not been addressed yet.
So it is still very much an open issue. There has been some regulatory guidance issued, but frankly, it kind of clarified the things that we didn't really need clarified. It sort of missed some of the most important stuff. So it's really kind of a fluid situation here. And especially when you combine this with the increased limits, which I think is maybe our next slide, the increased limits for those age 60 to 63, it's really been sort of a scramble, and it's been a scramble across multiple years. At first we were really hustling to get it in place, then there was a delay and then further delay. So this one's been very much a moving target. And I don't know, Bob, do you want to add anything to that? I guess to the point of the last bullet point there, kind of along the lines of what I said earlier. If the plan doesn't offer Roth, and the plan chooses not to offer Roth, then the highly cops just simply couldn't make catch-up contributions.
Yeah, it's a very interesting, typical, but very, very interesting. Kind of reminds me of the ACA when they originally were going with adjusted gross income, and then they realized a year later that employers don't have the family's adjusted gross income for the year to determine certain things.
Well, in that case, in the ACA situation, the IRS had a fit of common sense and came up with the three three kind of wage-based, poverty-based,
Right.
that kind of safe harbor. So I'm not sure that the same outbreak of common sense will apply in this case.
Well, there's part of me, because I've been saying for the last 2 years that they're going to change it off of FICA wages because they're missing a large swath of people that they're trying to capture in this, right? Because it's really just trying to get the tax dollars in now for those people. There's part of me that hopes they do and they just go to, because it really would have been a simple, if you're a highly compensated employee, you
Right.
have to make your raw and take all this other stuff out of it. It would have made it a lot easier for the record keepers and the service providers, because they're all trying to figure out, take a law firm, for example. You have some people that are W-2 that are going to be above that, but then you're going to have all the partners that they're not in there, that they're
Mhm.
not going to be included. Um, so we'll see, but I do having a little more faith than I probably should, because I thought it would have been taken care of by now. I my gut is it will be fixed, because they will recognize that they're missing a group of people that they really want to capture. And my hope is that some of the industry will persuade them to go in the very simple direction of just saying highly compensated. So we're not doing all these different, to having different numbers for different reasons within the plan.
And that would be the best case scenario. My bet, I hope you're right. I hope I'm wrong. My bet is they kick this down the road at least another year. I don't,
Uh, yes, that's fair. I do think they will kick it down the road again, but I'm
if we're
hoping
doing
that
this,
hoping that
right,
extra year gets them there. Right. Yeah.
right. I bet if we're doing the Burr Morning Show in 2027, we're still talking about this issue. So, all right. Next one. Uh, this is one of my favorite topics. It should be. It's one of those that should be pretty simple. It's just an increased catch-up threshold for participants age 60 to 63. And the question I always get is, why the heck is it 60 to 63? Why is it not everyone over 60? Why is it not everyone over 50? Whatever. I my answer is I don't know. It's what Congress picked. So I'm sure there was some reasoning behind that. I have yet to hear I've heard different reasons, but I've yet to hear a very good reason. But this is you know, a positive, I mean, no way around it. It's a positive provision. It allows people to save more money for retirement. So, Bob, I don't know if you want to add anything to that.
No, just that I have yet to hear a valid reason for that 3 year window. So I think just for complexity
Right.
for
And
HR and the benefits staff. Yeah.
it gives people like us something to talk about, I suppose.
Right.
All right. All right. So on to our next big picture topic, and I'll kind of give a little bit of background here. First of all, neither Bob nor I are litigators. So we're talking about this more from a fiduciary standpoint. Many of you on this call, I suspect, are fiduciaries with respect to your 401k plans or your retirement plans. And as you probably know, there has been a ton of litigation in this area. Back 25 years ago, when I first started practicing with these plans, there was not a ton of litigation. There was little spots here and there, but not a ton. Probably almost 20 years ago now, 15-ish years ago, a couple of firms figured out how to make money doing this. And it has really trickled down. Most of the litigation we see is over what is referred to as excessive fees. Basically, the fiduciaries of the plan selected investment options or something else that cost more money than it should have, right? And therefore, the participants' benefits over time were reduced. Uh, and again, we're seeing all sorts of claims firms who are engaged in this. What we're also seeing now is some pretty novel type theories that are being advanced. And one that we've seen that, frankly, has just mystified me, but has apparently gotten a little traction, is litigation involving planned forfeitures. Okay. And as you can see on the screen, the case is generally alleged there's been a breach of fiduciary duty because the 401k plans have used forfeitures to offset future employer contributions instead of reducing administrative expenses for the plan. There's been an allegation that this somehow violates the duty of loyalty, prudence, et cetera, and all sorts of ancillary allegations around that. Again, most of these cases have been in the fairly early stages. There have been a couple of rulings recently that have gone, thankfully, in favor of the plan sponsors. So it appears to be that these are going what I think would be the right direction. Bob, I don't know if you want to add anything to that. I know the DOL's had.
I was going to say that it was nice to see the DOL actually come out and file a brief on behalf of, in favor of what they've been doing, excuse me, as far as forfeitures being able to be used for plan expenses, or to reduce plan contributions. So my gut is kind of like what you just said, Logan. This one seems to go in the right way. Once they get shut down a couple times, they'll move on to the next.
Yeah, it's not going to slow down the excessive fee litigation. I mean, but at least it's one avenue that appears to be narrowing, closing. I don't know what the right word is at this time, but at least it's not going to be huge. We hope it's not going to be a huge liability for employers. The excessive fee litigation is showing no signs of slowing down. We've even seen that trickle down to your traditional labor and employment plaintiffs firms that are including with their general, you've discriminated against my client letter. They include a paragraph at the bottom that says, we've reviewed your 5500s. It appears you paid excessive fees for whatever, and we want you to provide certain documents. Don't ignore those document requests. They're entitled to some of the things they're going to ask for. They usually ask for a lot more than what you're obligated to provide, but it's still something you can't ignore because there are penalties associated with not disclosing the documents.
Yeah, I think kind of within this vein of conversation, it is important to have a process in place for reviewing the fees, reviewing the investments. Most investment policy statements say we're going to meet at least once a year. I think it's important to meet at least quarterly. And something I was told 100 years ago, but the only thing worse than not having a process is having a process and not following it.
Right.
Well, typically ERISA litigation, and I think we'll actually go through this a little bit on the next couple slides, but if you have a valid policy and process and you come to a reasonable conclusion, that's more important really than the outcome. Mm-hmm. Most of the time. And I think you find, especially on the fee litigation, is people haven't reviewed their fees or their service providers in 5 to 10 years. Mm-hmm. And then all of a sudden, as the industry changes, there's a lot of compression in fees. So if you're sending out, I'm not saying do a full-fledged RFP every year, but at least once a year, twice a year, send out an RFI, which is just a request for information, just to see what the market standards are. A lot of times, especially if you have a financial advisor that's helping with the plan, they have the reports because they're getting them all the time. And that way you have it documented. So if it ever does come up, because it is just kind of an add-on for plaintiffs' attorneys now to throw some ERISA type of claim in there. You have it in place that, yeah, we looked at it. This is the reason we did it. You don't have to use the cheapest option out there, but you have to have valid reasons as to why you chose your option.
Yeah, I think process and documentation are so important. You've got to have that good process. You've got to have the documentation to back it up. Fiduciary training is now something that, 10 years ago, we would do that just occasionally for a few clients. Now it's something we do very frequently, and frankly, it's almost required. And One other point I want to throw in here, the 5500s, please be careful with those. Make sure that somebody is at least putting eyes on them and double checking them for obvious errors. If you don't, I can promise you that somebody else is. The plaintiffs firms out there are data mining those things. They are looking for outliers. And if they can find one, it's not going to be that difficult for them to find a former employee who's willing to let them put uh, the former employee's name on a lawsuit alleging that you've had, you somehow violated your fiduciary obligations, et cetera, et cetera. And even that's one of those situations where even if you ultimately win, you still lose because it's a very bad look. It's very expensive to fight those lawsuits. It's very time consuming. It's just not something anybody wants to be involved with.
And since a lot, and this is going to end up being more of a litigation thing. Um, and look, I don't know if you've been seeing it over the last probably 2 to 5 years, really the target date funds being targeted in what's going on and
Yeah,
claims being brought is because it's either a glide through or
right.
two, and then the committee doesn't understand what they have, so when they get questions, they don't really have a good answer. So say
Yeah,
all that. Go ahead.
that's been around for a while where they've there's been a block of people waiting for the next recession or whatever, and they were going to jump on all these target date funds. And to your point, Bob, the committee needs to be informed, and a lot of this, frankly, is on the investment advisors, right? The investment advisors have to present this in a way so that the committee members understand the to versus through. Are the target date funds managing assets to retirement or through retirement? There's a 15, 20-year difference there, right? If you're managing to age 65, managing to 80 or 85, right? It's a huge difference in how things are allocated. So that really, you need an investment advisor that you can rely upon, that you can trust, that's a partner that is helping you out along these things. It's pushing you to do quarterly meetings. It's taking minutes for the meetings. Anyway,
Say all that just to pay attention and make sure that the committee understands not just target date, but all the funds and why the selections are made. Um, eh, Oddly enough, and I never would have thought this, the disparity in returns for the target date funds are astronomical.
mhm.
Um, Depending on what fund you choose. So as with any fund, just make sure it's performing within your boundaries, and also make sure that they understand if it's to or through and what that glide path is. So
Okay.
sorry, just had to throw that in. It just popped in my
No,
head
well,
for
we
it.
got a little sidetracked there, but that's
Well,
okay.
I know. Got me all excited about litigation.
All right.
So
Go ahead, Bob.
no, I'd say so, if you remember, and time flies, but I want to say 4 years ago, there was a big release that all of a sudden ESG could be a factor in determining funds. Um, Thought it was really odd at the time that it could be kind of a stand. It couldn't be the only factor, but it could be the deciding factor if all things were being equal. I was actually telling Logan yesterday, I had a place out of DC calling, wanting to see if I would do an opinion on ESG funds and including them in plans because they were really excited. And I was like, it doesn't make a whole lot of sense. And I'd probably wait a little while before we did anything on that. So this is the first ruling that I'm aware of, Logan, that truly addresses that you you have to do it in the best interest of plan participants' financial benefit, not and can't consider ESG as the only factor.
I think that's right. And I think the a couple of important things. I think it's a kind of to your point, it's a pushback on the kind of wave of ESG stuff we were seeing for the past several years. Um, Number one, but number two, uh, what I think it's important to point out what it's really saying, and which is ESG can't be the only consideration. There is nothing stopping a plan from having funds available, so long as those funds are reasonable and prudent, and meet your other criteria as specified in the investment policy statement, right? That take ESG into consideration. I think it would be problematic to have it as a default option. I think it'd be problematic to have it as the only options, right? But if it's an option and standing alone, the investment itself is reasonable, prudent, et cetera, I don't think it would be that much of I don't think it would be that much of a concern. And again, in our role, this is a political hot topic. We are not political, and the advice we give or certainly and not in this presentation, but politics are intertwined here, right? So it's something that I think I've seen a lot of plan sponsors kind of tread carefully around. Uh, but if it's something that's important to your organization, I think you can still do it. You just have to be careful with it.
Yeah, and I think, to oversimplify, the bottom line is the returns of the funds, right?
Yeah.
I mean, you can't pick a fund that, for ESG purposes, that's going to underperform another fund by, 4%.
I'll tell you where else, the other place I've seen it is with pension investments. Probably an issue for most of the people on this call, but larger pension plans, looking at the funds in which, and they invest in all sorts of funds that are not necessarily publicly traded, but looking at those funds and having to peel back the layers of the onion on them to see if, what they say about ESG. And in that case, especially with certain state laws that are out there, we have to make sure that that's not a factor in what these funds are invested in, or especially with some of the state kind of governmental pension plans, that sort of thing. So,
yeah, and I was, 4 years ago, the advice was and still is, it kind of died off a little bit, but if you're hiring an investment advisor or someone to manage the plan, these are questions that should be asked as far as their ESG, and a lot of them were putting the ESG information within their brochures, and we're doing it in interviews. So make sure, just another thing to think about, and make sure that their views align with your corporate views.
all right. Well, I didn't think we were going to get here, Bob, but I'm pretty excited. We've made it to what I think is the last slide. So
It is.
yeah, so we've gotten a lot of questions on PBMs, and I'll be completely frank here. This is a moving target. There are so the PBMs, basically prescription benefit managers, right? And there are all sorts of state laws out there now that are attempting to impose regulations on them, what they can pay local pharmacies versus the Walmarts and CVS's of the world, that sort of thing, and how that affects plans, in particular self-insured group health plans. Some states are fairly restrictive in their scope, Alabama being one of them. Other states are much more broad. Florida, for example. Many of you have probably seen the attestation, it's easy for me to say, that is required in Florida now for plants, right? And you may be wondering about how to deal with that. In Arkansas, for example, Arkansas was the original test case of this. Their original PBM law went all the way to the Supreme Court and was upheld. But a part of that has now been put on hold. There was actually a part of it that prevented PBMs from owning local pharmacies. And shockingly, that was vacated by a district judge, saying that is unconstitutional and can't be imposed, at least at this point. So huge moving target right now. I don't know that we're going to get, I don't think we have time, nor do I think this is really the place to get too much into the details of this. Bob, I don't know if you wanted to add a little bit of color to any.
No, I was going to say, I think I haven't seen a challenge to Florida, and just Alabama's, I think, is good. But if you have questions, I know we went through it with Florida, I guess the end of 24 when they were sending out the original request. Um, Clients couldn't decide if they should share the information or not, because, there are privacy requirements and not necessarily HIPAA, but we need to make sure that the state has security for their the information that they receive to make sure our client data is not getting out, our participant data is not getting out. Um, and I think some of the states are working on that, but my guess is 2 to 3 years before this all shakes out, um, to see where we are. I think the Supreme Court did do a pretty good job of kind of defining the lines of what would be an overreach and then be preempted by ERISA. And as soon as I say that, Florida does theirs after that ruling, and it appears to be an overreach to me. So, um,
I think Florida's pretty clearly an overreach, and the question is just going to be who's going to be the first to challenge.
exactly.
Who's going to be willing to spend the money to take the fight to the Supreme Court, which is what it's going to take. And shockingly, plan sponsors aren't lining up to do that. But it's really been surprising in looking at these and sort of becoming more aware of the state of things with PBM laws, just exactly how much legislative insurance local pharmacies have with state government. It's really amazing. These are very, very popular statutes when they get passed. So it's something that the states, it's a win-win for the legislatures. They get to make a lot of people happy and get to strike a blow against the big mean PBMs and help out the little guy. So we'll just have to see how soon the challenges line up for some of these that extend a little beyond what the Supreme Court has authorized.
Yeah, and my guess is every state legislature has at least a couple pharmacists on as members, right?
That certainly seems to be the case.
So I never would have just never thought about it, but yeah, it's been fascinating.
All right. I think we've come to the end of our slides. We have the question and answers or Q&A open, but I don't see any questions so far. We'll give it a couple of minutes. Bob, while we're waiting on any questions that might come in, do you have anything you wanted to add? Anything that we may have skipped over or anything like that?
Don't think so.
Yeah, I think we covered most everything. I'll tell you just a couple of the big topics that we see. I've seen that, just didn't make it into the presentations. Leave management, eligibility for benefits, how, in particular for self-insured plans, how your eligibility for the plans work with your COBRA obligations, with your stop loss coverage, with the requirements of the Affordable Care Act. And you had oftentimes different sets of rules for all of those things and how they mesh together. For whatever reason, that's been a popular topic over the last few months. I don't know if there was some big stop loss conference out there where the carriers got together and said, hey, we need to pay attention to eligibility and make sure that the people we're paying claims for actually are supposed to be covered. I don't know, but that's something that we've seen pretty frequently. So if you're seeing those type of challenges or those sorts of questions, please feel free to reach out to us. But that's really about the only thing I wanted to add to this. All right. I'm not seeing any questions. That could be could be operator error. Oh, here we go. Here's one. I don't know who sent this, but it says not a question, but a statement. We've included the 4 new withdrawal options. Since our withdrawals are self-certified, we've seen some employees take advantage and request multiple withdrawals or request for each reason. We are looking to put some limits around the number of requests they can take within the dollar limits allowed. All right. So I think, first of all, that's a pretty common problem. No matter what situation, no matter what system you put into place, you're going to have some employees who are going to game that system. They just are. Um, I don't think there's a great solution to that. I think you can impose limits on the withdrawals, how many per year, that sort of thing, and that may help some, but I'm not telling you something you don't know, but people are always going to find a way to game the system, and that's part of the hesitation I think that I have, and I think Bob has with some of the withdrawals, the emergency withdrawals, some of the others, is it's just a further opportunity to access funds that would otherwise be protected for these people's retirements. Now you can't save people from themselves, but anyway, I think what you're seeing is a valid concern, and I think that's a good question/statement. Certainly appreciate everyone's time this morning, and we will look forward to seeing y'all again. Thank you.
Thank you.